I'd like to greet you all. My name is Mert Ülgen. Presently, I'm employed as a research assistant in the Department of Criminal and Criminal Procedure Law at Istanbul Yeni Yüzyıl University. I also am a PhD candidate at Istanbul University. First of all, I wish to thank sincerely to Professor Adem Sözer for the opportunity to allow me act as a sessions presenter in today's sessions of the 9th of Law on the Bosphorus, International Criminal Justice and Human Rights Law Summer School 2021. Let me please introduce you the presenters in our first session. Ms. Rahime Erbaş, who is employed as an assistant professor in the Department of Criminal and Criminal Procedure Law at Istanbul University. Mr. Ege Kavadarlı, who is a registered lawyer in Istanbul Bar Association, and Ms. Şeyma Kuş, who is employed as a research assistant in the Department of Public Law at Piri University in Istanbul. The cooperative paper in today's first session is titled as Effective Criminal Investigations in Combatting Domestic Violence Against Women. Before we start, I'd like to kindly remind you that we have 45 minutes for your speech. Then we'll move on to the questions and answers. Questions for the Q&A discussion can be placed into the chat box. You may start your presentation now. Please, honorable presenter, the floor is yours.
Thank you so much, Mert. I am also so happy to have an opportunity here to speak. Also, I would like to thank my professor, Professor Adem Sözer, enabling us to have a presentation here. And as you said, we are going to talk about effective criminal investigation for the victims of domestic violence. Why this topic important and what we do, what we discuss. I just briefly introduce our presentation plan. First of all, I would like to welcome all of you, dear esteemed colleagues and dear esteemed students. Good afternoon to everyone. My colleague Mert introduced me and my colleagues, so I just quickly take another step, and I would like to mention why we have chosen this topic to present you. Because maybe to make this case or this domestic violence phenomenon, we have to make it the first clear with a concrete example. Maybe you heard in criminal law we have a fact-based criminal law, not a perpetrator or not a defendant-based criminal procedure. And the main problem is in our system, the classical tools and classical or traditional understanding of criminal law doesn't help or does help in a very low level in the case of domestic violence. Therefore, I would like to begin my speech with a comparison between a domestic violence case and burglary, because I choose burglary because it's a typical type of incident-based crime. There are huge differences between domestic violence and other type of incident-based crime type. Why I describe this as a burglar as an incident-based crime? Because just only one action occurred by the perpetrator, and it was addressed and trialed by the court, and this is a very clear incident-based example. And if we look at the domestic violence case, we see, for example, assume that a man breaks into the house, takes the jewelry at home, and manages to escape, and police catch the perpetrator, and the prosecutor collect the evidence, all fingerprints from the surface where the perpetrator touched, and determines the act of taking someone belonging. So it is very clear in the code, also in the procedure. So the prosecutor submits the indictment and the trial begins. When it comes to domestic violence cases, the situation is completely different. Imagine a woman frequently experiences defamation, threats, bodily harms. For example, one day, after being injured, she goes to hospital to have her injuries reported, maybe she also managed to go to the hospital very late, and the medical report unfortunately cannot be obtained, or the biological evidence become less available than other evidence in many cases. So also maybe the victim woman suffer from the well-being of her child at home. Also children, maybe they also witness all the crime or all violence at home. So in this case, for example, the first problem, police may arrest the husband, and the woman can easily withdraw her complaint under the pressure of her husband, partner, or the people or family of her partner, or even by herself, for example. In many cases, women, of course, they don't, I mentioned in my speech, as a victim, I refer the woman, but this is not a discrimination. In many cases, statistically, the overwhelmingly majority of the victims are women. Of course, even if the number is tiny, there is also a man victims of the domestic violence. Also, it is a broad term, even mother and father or other family member also become a victim of the other family member. But in my speech, because of this reality, this majority, I will refer to all throughout my speech, I will use women as a victim in my case. So in our situation, women maybe as we see in Opus case, women, for example, they withdraw their complaint, and in this case, for prosecutor or other police officer, it is very difficult to obtain evidence. And biological evidence, they are also from forensic medical perspective, there is only 72 hours cutoff time. It means after this hour, biological evidence lose its originality and its meaning. So if considering for example, in the eyes of the public prosecutor, if there is no complaint by the victim, how and why the public prosecutor or police officer should continue pursue the case. And also the situation at home, also children well-being. Also, the other issue is there is an ongoing relationship between the perpetrator and victim. And all the time, as I said, women, they don't want to, women victims, they don't want to send their partner to the jail. What they all want is just only stop the violence at home and keep their family well-being. And therefore, in many cases, also women, they are keeping hope for a future, and they are believing also, maybe hoping that the relationship will be recovered, and then so they have a huge hope for their future, and therefore they don't women, they don't wish or has no willingness to cooperate with the judicial authorities. And in this case, considering the lack of evidence, considering this kind of complaint issue and many aspects, so this is the continuing relationship between perpetrator, and it is a repeated nature of this relationship. And it is, as I said at the beginning of my speech, there are huge differences and challenges for the prosecuting domestic violence cases, and there are remarkable amount of the case before the European Court of Human Rights, and the most famous one is, of course, Opus case. It is I consider and describe Opus case as a constitution of the this violence against women issue. And the Istanbul Convention also drafted after the Opus case, based on mainly Opus case. It's a huge and very landmark decision. And as I said, also a very recent case from the European Court of Human Rights. It is also stated domestic violence and also violence against women, these are underreported, understated, undermentioned. So we need there is a huge need for conducting an effective investigation, and impunity and lenient punishment for the perpetrator of this kind of violence is a huge concern among also feminist side, also among the penalist criminalists. So in order to combat this phenomenon, this impunity, lenient judgment in the case of domestic violence, it is necessary to create a system where this kind of cases are prosecuted efficiently. And also we will mention time to time the approach of the European Court of Human Rights. As I said, there's a huge amount of cases before the European Court of Human Rights. Especially, I noticed these most of them come from eastern part of Eastern Europe also, and Turkey. I saw a lot of cases from Moldova, from Slovakia, from Romania, from Bulgaria also, and also Turkey. And yeah, as I said, also Russia and Albania. There is of course, there are a lot of cases against other countries in Europe, like against Talpis, against Italy and Germany, even there are, but majority of I observe there is a huge struggle in Eastern Europe to combat this violence against women, but contradictorily also there is a huge contradiction against the Istanbul Convention. At the same time, in these countries, we observe also Poland, the same situation. So in our speech, I would like to, as my colleague said, we are going to talk this issue with my two students and my colleagues also. They are, as my colleague Mert introduced them, Ege Kavadarlı and Şeyma Kuş. For me, of course, it's a great happiness to have a speech with my students. And in our speech, our main aim is show these challenges and carrying an effective investigation, criminal investigation. And in this regard, we plan to discuss components of such investigation, what should be done, what should be considered, and what should be additional measure to combat this phenomenon, especially state duty, which is take action with due diligence standard as the European Court of Case Law settled on. And our final point aim is to come up with concrete evidence-based recommendation. We imagine a country where there is no effective investigation or there is a poor investigation. How can we create such a system where these victims has a support and they have an opportunity, this kind of measure. So in our speech now, after my this brief introduction, my colleagues Ege Kavadarlı will speak these challenges on domestic violence cases from the side of criminal justice system. He explained what is domestic violence, especially from the UN definition, also Istanbul Convention definition, what is criminal investigation, which is a effective one. And then my colleague Şeyma Kuş also, she is going to speak on due diligence standard. It is relationship with domestic violence case, because this due diligence standard is also come from originally international law, and now we use this term in criminal law. It became after the case law of the European Court of Human Rights, it became a component of the effective criminal investigation. And then she described what is due diligence, how it become a phenomenon, how it can be turned to standard, and what is international law background, and what is the European Court of Human Rights approach in this. And finally, after my colleagues, I indicate our core points and recommendation to create a system where there is an effective criminal investigation I'll carry out. So I give the words my colleagues Ege Kavadarlı now.
Thank you very much. Greetings, my name is Ege Kavadarlı. I'm studying criminology as master's student in Istanbul University, also working as a lawyer in Istanbul. My presentation will be about, just as stated, about combating violence against women in general, and in specific, effective investigation phase for this phenomenon. I'm planning a short presentation, so I'll have to hear the questions at the end, just like my supervisor Rahime Erbaş said. Okay. Acts of violence against women are recognized as one of the most common human rights violations in the world. World Health Organization defined these types of crimes as not only violation against human life, but also a public health problem that needs to be resolved. In many studies, it has been underlined that the gender inequality and patriarchal social beliefs are the basis of violence against women. Similar researches state that many actions that have been taken by authorities, politicians, and even regular people actually make these false beliefs to have an impact and ultimately become the source of violence. It has been emphasized that the situation continues with current political orientations, social interactions, and false family teachings. Because of its complicated nature, violence against women can occur differently in each concrete case in terms of reasons for its perpetration, the perpetrator-victim relationship, its form, and other relevant factors. Although the incidence of violence against women differ in terms of certain elements, statistical studies on the subject show that the majority of this incident occurs between family members, mostly husband and wife, or people in close relationship. In order to understand how dangerous of a problem violence against women and domestic violence is, it is crucial to examine the statistics presented in the studies on the subject. Such comprehensive examination will reveal the importance of preventing this type of violence and will help adopting effective investigation. Additionally, it will help highlighting the importance of deterrence policies towards this subject. The prevalence of violence against women, which can occur in form of psychological, physical, economic, and even sexual violence, is overwhelmingly high when compared to different types of violent crimes. The result of statistical research that has been conducted in Turkey about domestic violence against women showed that 4 out of 10 women have been subjected to physical or sexual violence. Similar research that has been conducted by World Health Organization has revealed that almost 30% of women all over the world have been subjected to physical and sexual violence. And half of this has been committed by their partners or spouses in a direct, close relationship. United States-based organization, National Coalition Against Domestic Violence, conducts extensive field research on this issue. Results of some of the researches showed that every minute in the United States, 20 people are exposed to violence by their partners. Reports additionally showed that in 1 year, the number of people who were exposed to violence by their partner in USA reached 10 million. Considering these theories regarding the emergence and prevalence of violence against women, and especially domestic violence, it is clear that these crimes should be evaluated differently from other and more spontaneous crimes. Because of its nature, it is extremely hard to imagine that the domestic violence and further crime will stop after only one incident. On the contrary, many academic researches and real cases on this issue show that repeat victimization is a huge factor in domestic violence. The fact that offender and victim are in a close relationship and they often live in the same house increase the chance of recurrence. Reporting sexual or physical violence that occurred in the family to the authorities can be difficult for victims because of certain issues. Lenore Walker's extensive research about women who did not inform the authorities after domestic violence or did not leave the house that they are being subjected to violence showed that it might be due to battered woman syndrome. According to Walker, as a result of repetition of physical, psychological, or sexual violence, these women cannot break the violence circle, do not dare to leave the environment that they are in, or cannot take the necessary actions. This caused the problem to only get bigger in time without any hope to resolve it, often ends with the death of the victim. In addition, some studies have shown that inability of gain their economic independence is the reason for women to not being able to leave the violent environment. However, it should be underlined that the existence of this issue is not a necessary condition, because there are studies showing that even women who have achieved economic independence and are at the top of the career ladder can be exposed to domestic violence as well. Statistics show that majority of people choose to go to police to report a crime. Confidence in law enforcement and their approach to the case at hand is important in whether a crime is reported by a victim or not. Victims' own idea of police's reaction to their problems are also a very important factor of crime being reported or not. In a survey conducted by Henrica and friends on violence against women in Turkey, women were asked which office they went for help after being subjected to physical violence. And 91% of the participants stated that they did not inform any authorities at all. In a study conducted by Belma Gölge, it was determined that the rate of women who were sexually assaulted did not report this to any judicial authorities was more than 90%. As it is well known, sexual assault can be committed between spouses and is considered one of the forms of domestic violence. While unreported cases of sexual assault are at a staggering rate of above 90%, it can only be assumed that cases of domestic sexual assault between spouses can only be higher than this. However, it is among the primary duties of authorities to deal with these issues, such as the negative approach of police officers to the incident, changing the opinions of the victims about the approach of police to the incident, to work it to make more positive, ensuring full protection for victim during investigation, also ensuring that any type of violent behavior is investigated effectively after the report. In a comprehensive survey conducted by Hamzoğlu and friends, 69% of the participants stated that they think police are not working their cases properly. This generally indicates low trust in law enforcement, thus eventually create a negative impact on reporting the crimes. A survey conducted with police officers in the United States revealed that 60% of the participant police officers think that husbands have a legal right to beat their wives when it's necessary. As it stated before, harmful patriarchal thoughts and that are far from equality are the most fundamental source of violence against women. These kinds of thoughts and factors like acceptance of social situations that are legitimizing the violence are the issues that must be eliminated first in order to prevent this violence altogether. The elimination of these negative thoughts and beliefs should be carried out primarily for law enforcement officers and judicial officials at first, because their approach may cause victims to not be able to seek a safe shelter from them or not to report the relevant crime in the first place, and this causes them to easily submit to violent behavior. In the sentence of Opus versus Turkey, the European Court of Human Rights stated that the victims of domestic violence in particular tend not to report the relevant situation or crimes to authorities, or they tend to withdraw their complaints in the process after reporting them. In this respect, it is important to expand both quality and quantity of prosecutors' offices that are specialized on violence against women. Crime-specific prosecutors are more effective because they have comprehensive education on the subject, and they are leading the investigation from day one to the end of the trial phase. Even creating a police force that is specialized in domestic violence and violence against women could be effective to fight against this phenomenon. It should be clearly understood by the police that secondary victimization of the victim must be avoided at all costs. The fact that the crime in question occurs within the family is not a reason for looking at the case any differently. Misinterpretation of social beliefs and morals unfortunately leads to emergence of some unprofessional behaviors in this regard. Law enforcement may choose to approach domestic violence as a private matter within the family, which is noted in Gravio's report as well. Considering how harmful that is for the investigation and for the victim, this type of approach must be abolished. In the Turkish Criminal Code, the crime of intentional injury is regulated in Article 86, and injuries that can be remedied with simple medical intervention are sanctioned depending on the complaint only. However, committing this crime against spouses constitutes the qualified form of this crime. In this case, as it's known, a higher rate of penal sanction is foreseen, not dependent on the complaint. Therefore, it is necessary to avoid approaches to these files, such as private matters, family matters, especially physical violence. It is very important for the authorities to understand and actively implement the issues of the victim's statements being sufficient and enough to ensure protection of the victim. This is also underlined in Gravio's report of Turkey and stated in the Acts of Family Protection and Prevention of Violence Against Women. After the victim's first complaint and statement, it is important to ensure that victim is taken into the women's protection shelters and they are not brought together with their spouses during investigation under any circumstance. As in the Opus case, the negligence and inaction of authorities should be abandoned immediately, and the requirements of the law should be fulfilled immediately as well. It should be known that the sanctity of the family and respect for this institution cannot make domestic violence behavior acceptable in any level. Taking the necessary protective measures for the victim after the first complaint is part of the authority's primary obligations. Taking the necessary measures not only helps protecting the victim from further crimes, but also make it possible to conduct a powerful investigation. Protecting the victim of domestic violence during investigation and prosecution phase is also mentioned in Gravio's report. Gravio team strongly recommend party states not to delay these actions due to bureaucratic steps. This is surely an extensive topic, Even if I would love to talk about it in more detail, I cannot since the time is limited. So thank you very much for your patience and for your attention. Now I would love to give the word to my supervisor, Rahime Erbaş. And thank you.
Thank you, Ege. Before giving words to the Şeyma, I just would like to mention this due diligence and in terms of effective criminal investigation, European Court of Human Rights actually has conducted some step in this regard. For example, in the Opus case, the applicant and her mother exposed multiple assault by the applicant's partner, and at the end of this, it was a long period, and there were various and severe also assault in this case. But at the end, the applicant mother was killed by the applicant ex or partner, I must say. And in this case, European Court of Human Rights, according to me, follow a circle which I try to sketch here. You can see. I consider or call this as a circle of analysis for an effective criminal investigation. And here the core point is, as you see here in the middle, actually it is a positive obligation, and it means state also has to take action to protect citizens. Traditionally, state all the time, it was told, state shouldn't intervene in the human rights of the individual. This was called negative obligation. Also, when the European Convention on Human Rights, when in the first time this convention was drafted, there was no obligation, such a positive obligation. It was not mentioned clearly. And this positive obligation, the state obligation to take action to protect or secure, ensure the rights of the individual also against the private person action, illicit action. This was a new concept, and this is a very new concept. And also in this regard, it is also settled down in the case law. And in the Opus case, the court look at there is a positive obligation accepted in this country. And if the country or state has no such a concept or sense, there is no meaning to discuss whether should state carry out an investigation or not. Here is very important. The state must accept, I have this duty, and also recognize and do everything what is necessary to fulfill this positive obligation. For the Opus case, of course, the inner point is the state must take these necessary measures to take measures to protect right to life or right to private life. This kind of all rights listed in the convention. And secondly, is this obligation, positive obligation, fulfilled? And in this case, in Opus case, the attack to kill the mother of the applicant is unforeseeable for the authorities. And did the authorities display due diligence? And after the taking the issue, addressing issue in a due diligence standard, and also after this, are necessary measures taken by authorities. So in this schema, in this circle, I would like to give the words to the Şeyma to mention us this due diligence standard.
Thank you, Dr. Rahime Erbaş. Firstly, I would like to share my screen with you. Are you able to see my full screen presentation?
Yes, Şeyma.
Okay, thank you. Hello, everyone. As my colleague, Mr. Rögen and Dr. Rahime Erbaş mentioned, my name is Şeyma Kuş. And in my presentation, I will explain the due diligence standard and its relationship with violence against women. But firstly, I am very happy to participate in International Criminal Justice and Human Rights Law Summer School 2021. And I would like to thank the organizer of this meeting, and especially Professor Adem Sözer. You may have heard about the European Court of Human Rights landmark decision Opus versus Turkey case. Between 1995 and 2008, For 13 years, Ms. Opuz and her mother were repeatedly abused and threatened by the victim's husband. When victims reported domestic violence to police stations, police officers did not investigate their complaints, but they tried to convince the victims to return home and drop their complaints. To the police officers, this problem was a family matter which they couldn't intervene, and these threats and attacks resulted in the murder of Mrs. Opuz's mother. The European Courts of Human Rights decided that the national authorities had not shown due diligence in preventing violence against the applicants and her mother. As you can see, the court has been accepted and implemented the due diligence standard on domestic violence. So, what is due diligence and what is the relationship between due diligence and violence against women? Basically, due diligence is states to respect, protect, and fulfill human rights with diligence. It includes the obligation to prevent and prosecute violations, protect the victims, punish perpetrators, and provide redress and reparation for victims. Let's now take a look at the subject historically. Due diligence standard was first used in 1988 in the American Courts of Human Rights landmark decision in Velázquez-Rodriguez versus Honduras. The case was about disappearance of Mr. Velázquez. The state was ineffective in proceeding results and judicial proceedings about disappearance were handled inefficiently. The court held that an illegal act that violates human rights that isn't directly imputable to a state can lead to state's international responsibility. And this is not because of the act itself, but because of the lack of due diligence to prevent the violation or to respond to it. Secondly, due diligence was discussed by the CEDAW in the context of domestic violence. In its recommendation number 19, the committee stated that states may also be responsible for private acts if they fail to act with due diligence to prevent violations, investigate and punish acts of violence, and provide compensation. As I pointed out so far, due diligence standard has been used by international courts and United Nations. Now, let's move on to the regulation of the Istanbul Convention. Firstly, I'd like to stress that Istanbul Convention is the most comprehensive convention on violence against women. Article 5, paragraph 2 regulates a duty of due diligence of states. According to the article, states shall take the necessary legislative and other measures to exercise due diligence to prevent, investigate, punish, and provide reparation for acts of violence covered by the convention that is perpetrated by non-state actors. And this standard is also handled in the explanatory report to Istanbul Convention. The report cleared that Article 5, paragraph 1 addresses the state obligation to ensure that their authorities refrain from acts of violence against women. On the other hand, paragraph 2 sets out the parties' obligation to exercise due diligence in relation to acts perpetrated by non-state actors. In both cases, a failure will incur state responsibility. However, it should be emphasized that due diligence obligation is not an obligation of result, but an obligation of means. Secondly, let's move on to discussion on the subject. Due diligence standard has become an important argument on violence against women. However, there is an ongoing debate about the standard. Some scholars have pointed out that there is no accepted definition of due diligence, and also there is no clarity of its scope. According to them, the lack of clarity of the standard weakens the positive obligation of the states. Briefly, because of due diligence, a wide margin of appreciation is created for states. On the other hand, the other scholars have argued that this standard imposes an important obligation on states to combat violence against women. As it is known, violence against women occurs generally in the private sphere, especially by intimate partners. And for a long time, states have avoided intervening in violence against women due to the distinction between public and private spheres. With the due diligence standard, a solution has been brought to this dichotomy. And since then, it has been accepted that states will also be responsible for actions taken by non-state actors in the private sphere. To clarify my opinion on this debate, I can say I acknowledge that there is no accepted definition of the due diligence standard, and there may be a lack of clarity of its scope. However, many organizations, both regionally and internationally, set standards on how the due diligence standard can be applied to violence against women. If we look at the Gravios or UN Special Rapporteurs on Violence Against Women reports, we can see that they have explained how the due diligence standard should be understood and how the due diligence standard should be implemented. As a final point, I'd like to emphasize that violence against women is a fact that exists in all societies. The due diligence standard ensures the active participation of states in the struggle. Therefore, this standard is one of the most important steps taken to combat violence against women. Finally, I would like to express my pleasure to see that great steps have been taken and great progress has been made on violence against women in the 10 years. However, I would like to stress that I am concerned about the undeniable increase in femicide all around the world. So, to further the gains we have achieved with Istanbul Convention and for future violence-free, I would like to conclude by saying the slogan of the convention: Istanbul Convention saves lives. Well, this brings me to the end of my presentation, and thank you for your attention.
Thank you, Şeyma. As a final point, I just would like to, what is our recommendation? What should be done to create a system, a justice system, where there is a effective criminal investigation? So our first recommendation, also it is supported by the psychological studies, is in many cases, there is no effective investigation or there is no cooperation by police or other justice authorities. The core problem is the absence of an independent judicial system from society's misconception. As also Ege mentioned, highlighted, in many cases, this case, domestic violence or violence against women, is considered as a family matter or family issue. Also, even in some cases, in European Court of Cases, I saw also some dissenting opinion. It is also considered as a personal contradiction or personal fight among two persons. This kind of weird definition, weird considering I saw in this dissenting opinion. And in this regard, as also Şeyma also highlighted, this public-private distinction, also from a feminist approach, the problem is, as Ege also mentioned, the definition of the domestic violence, it is a public health issue, but at the same time, it is a woman's human rights violation. And traditionally, human rights is developed or earned in the streets. People fought in the streets or university campus or police station. These are struggle or these challenging things for gaining human rights or managing things also happen in public area. As I said, torture, for example, torture is a typical example of this kind of thing, for example. But when it comes to this kind of domestic violence, it is happen in private circuit, and therefore it is also, it become behind it all the time, remain behind the doors. So therefore, feminists also, from feminist point of view, the women has a disadvantage here. Improve or protect their human rights, because under the family, under the protection of family, under the right to private life, also in many cases defendant argued this, this is my right to private life, privacy issue. And therefore it is very important to make a division between legal interests to protect a person's life and protect a person's bodily integrity, but on the other, there is a family. And where there is a woman or any person in the family life is threatened, we cannot talk about a family. So we have to make this distinction, and we don't allow the society's misconception enter in the judicial system. So in also Opus, European Court of Human Rights highlighted police citation. In many police officers sees the family, these cases as a family matter, and they took as a position as a mediator between them. They even see this as a good thing to bring family together. But after 1 day, the woman is killed by her husband, for example. And therefore, this is our first point. Domestic violence, as I said, appears to be tolerated by the national authorities when we allow the society's misconception entered in the judicial system. And the second issue is the term domestic violence and its legal qualification in the criminal code. For example, in Turkey, we don't have a crime type as a domestic violence. Even the term violence is a criminological term. Maybe we don't need it. We have a crime of injury, we have a crime of murder or sexual assault. And there are also, as also Ege mentioned, there are some aggravating circumstances when this committed against spouse, for example. And therefore, as opposed to Turkey, for example, in Spain, in Spanish criminal code, there is a crime of domestic violence. But therefore, in many cases, we maybe fail to recognize the whole picture. And our core point here, we have to adopt a holistic approach. As I said at the beginning of my speech, this is not incident-based case. If we concentrate on one act, there's a many act, various acts throughout the years. And if we address all of them, each of them by different prosecutor, for example, we cannot see the whole picture, and we cannot help the woman or children in this case. Therefore, we need a much more concrete definition. And this is another point. And for our country, also in other countries, I noticed from the European Court of Human Rights, there is a crime type like mistreating family member. It is also a very fundamental crime type. But in this crime type, we protect not the person, I mean, at the first side, we protect the family order. And the third point, our third recommendation, creating an appropriate labor division in prosecutorial system. We have this system. It is a very new in Turkey. We have a special bureau in prosecution office. We have a special prosecutor for the domestic violence and family issue. And in this regard, I think in Turkey we had a great important step here in this regard. And the other issue, other point, we would like to emphasize victims' vulnerability, and in this regard, pursuance of the complaint by victim. In the Opus case, one of the big obstacles is in many assaults, the applicant and her mother, they withdraw their complaint. And because the court require a complaint for this kind of crime, and the prosecutor has to close the case. And but European Court of Human Rights argued here, we shouldn't follow a formal approach here. We should concentrate a much more material aspect. We should concentrate some peculiarities of the cases. In this regard, I had also another schema. I think I cannot open this file, but maybe briefly I can mention this. In the schema, I try to take some peculiarities to reassess, reconsidering the necessity or pursuit of the complaint. In the first regard, I just try to make this as a fourth step for timely spread. A prosecutor first should, what is prior to prosecuted crime committed in the past, what was happened? For example, a defendant criminal history, particularly any previous violence. Also the history of the relationship, particularly if there had been any other violence in the past, for example. And also prosecutor considered what happened after the commission of crime. I mean, here in the current situation, the seriousness of the crime committed, for example, and also whether the defendant used a weapon. Also, what kind of weapon is this? For example, whether the defendant planned this attack or just committed spontaneously, whether the victim's injuries are physical, psychological, for example. The other is a thing prosecutors should look is a new acts after the prosecuted crime committed. For example, in this regard, I also consider as a what happened after the commission of this crime. For example, whether the defendant has met any threats since the attack, or the continued threat to be held and the safety of the victim or anyone else who was or could become involved, for example. And the last point a prosecutor has to look at is the prospective crimes. I mean, here I refer to future. For example, the chances of the defendant reoffending again, for example. The effect, for example, this impact or crime effect on the any children living in the household. For example, the current state of the victim's relationship with the defendant, the effect on that relationship of continuing with the prosecution against victims' wishes, for example. In this regard, also, as I said, European Court of Human Rights says, even if formally maybe courts or other legislative, for example, they require a complaint, existence of a complaint, we has to avoid this. We shouldn't, we have to prosecute it ex officio, not ex parte, for example. These are our another recommendation for creating such system. And so, as I said, this is a public health issue. We need create a system. Classical tools of criminal law doesn't help us, and we need to take a holistic approach here. So, this is our presentation. Thank you so much for your attention. If you have any question, we will be happy to answer.
Thank you very much for your remarkable presentation. Now we are moving on to the Q&A section. As a reminder, if you have any question for the Q&A discussion, it can be placed into the chat box, but there's a question right now. So let me vocalizing it. Thanks for all presentations. I'd like to ask about how we can take much more useful measures for psychological violence, because it's the step of the physical violence.
It's a great question, because domestic violence or violence term is, as I said, it's a criminological term. And it's a very broad term, both in the UN concept, also Istanbul Convention also. It, of course, includes psychological violence also. It's, as our colleague said, yes, it's a big step to combat this violence, because in many cases, firstly appears defamation or other pressure, and then come bodily injury and other type, also sexual assault, also within marriage or within relationship. And I think it should be, but seeing that, for example, sexual violence within the family, for example, in many cases, also Ege mentioned, this is a very important point I would like to also emphasize. In our system, for example, in many cases in prosecutorial office, woman go to the prosecutor office by arguing because of the injury, crime of injury, not the crime of sexual assault. And maybe they feel shame, they may be scared, but it is easier to say public prosecutor, there is a crime of injury, for example. So therefore, in our system, in criminal code, even if this injury, crime of injury, very simple, and it can be cured by quick medical treatment, indeed, it's still ex parte prosecuted crime in the case of the victim is supposed or family members. So in this regard, psychological violence, we have a much more way to go. It is a very important, but in this sense, it is very difficult to manage, I think. I agree totally with you, but it is, for me, difficult to describe how to go further. Even the case, we cannot manage the prosecute sexual violence at home or other bodily injury.
Also, if I can add something,
Yeah, of course.
The worst thing about psychological violence is it is extremely hard to take legal steps against this. For example, for sexual assault and physical violence, you still have legal base to go on, and you can actually go for prosecution, and you can file a complaint, and you can follow the case later. But for psychological violence, it is extremely hard to make a complaint, and it has an actual impact. So, like I stated, psychological, sexual, or physical violence, all because of wrong patriarchal beliefs, very, very far away from equality. That's why, and it's because of some political approach to this and wrong family teachings. These are all part of this, and this is actually a whole big issue that cannot be divided. That's why, in order to avoid psychological violence, you have to go all the way back and to that person, the perpetrator's family teachings and primary education even. I mean, this is a very basic thing to avoid, and it's only can be accomplished when they were actually a child, in my opinion. It is extremely hard to avoid that later on, because that person has already have false beliefs, and they usually do not respect their spouses as a human. It can be avoided from all the way start and not later, in my opinion, for psychological violence, at least.
By the way, in Turkish law, this injury, crime of injury, not only bodily injury, but also psychological injury. Yeah, I mean, damaging someone's bodily integrity or psychological well-being. In this case, in our system, also it constitutes also crime, psychological damaging also.
Thank you very much. There is another question. Could you tell us more about this special prosecutor office about domestic violence cases? Does it only exist in the big Turkish cities?
Actually, in big cities, of course, it is exists, and there are multiple public prosecutor. For example, in Istanbul, in one district, there is a public prosecutor office for domestic violence. There are at least 5 or more public prosecutors. Also in small cities also exist. For example, in Amasya, in Black Sea region, it is a very small city. One of my students, she is now prosecutor there, and she is a chief prosecutor there for domestic violence. Actually, here in the public labor division in our system, in our prosecutorial bureau, it is considered what kind of crime type are mostly committed in this area. It depends. For example, if there is an amount of the case, for example, domestic violence is limited, or other crimes against, for example, environment, for example, there is an office for environmental crimes. It depends on needs and the amount of the cases. But also yesterday with these students, we discussed this issue, because we also in a simple, in a very ordinary murder case or ordinary injury cases, in our court cases also we observing in many cases there is a relationship between perpetrator and victim. In limited case, there are limited case where the perpetrator or a victim, there is the relationship weak or there is no relationship. For example, there is a traffic case. Of course, they don't know each other, but in many cases, majority of the cases, murder and victim, they are even relative, or they have an enemy, hostile relationship, or they are neighbors. In many cases, there are somehow a relationship. Actually, people tend to fear from the stranger, but in the court cases, we observe in many cases, crime are committed among the people known each other. So we discussed yesterday with my prosecutor students. In many cases, the case somehow come to the domestic violence office, and it is inevitable. So excess, I will answer as excess. If also my other students also would like to answer, because in my master class we have hosted prosecutors from this public prosecutor bureau. Also, my student also has an observation.
Thank you very much. If there isn't any other question.
By the way, I shared my 2 articles, which is based on our presentation today. Also, the students and colleagues, they wish to read further, they can look at in the chat.
Thank you so much, Ms. Erbaş. Now we have a break. We'll be meeting again for our second session at 2:10. See you again soon.